I'm Alex Grant, and this is the Law of the Case podcast for June 11th, 2020. Last week, the jury returned guilty verdicts on all 34 counts of the indictment in the Trump hush money case. In this episode, I draw upon over 20 years' experience as a former federal criminal prosecutor with the Department of Justice, where I tried cases and argued appeals. And I talk about the instructions that were given to the jury and whether they will give grounds for Trump to successfully appeal the jury's findings. Now, 2 episodes ago, I identified the state of mind that the prosecution was going to have to prove in order to convict Donald Trump. And part of that burden was proving willfulness. The jury instructions given by Judge Merchan attempted to explain the critical state of mind, or what we call mens rea requirements, for the convoluted charges brought by the district attorney's office. While I'm sure Judge Merchan was trying his best to avoid reversible error, I'm afraid that the jury instructions were fatally flawed around the mens rea requirements. I say fatally flawed because it has to do with that willfulness requirement that I talked about 2 episodes ago, and the complete lack of explanation and lack of guidance provided to the jury. Remember, this was the stumbling block that proved to be insurmountable in the John Edwards hush money case. I don't see how an appellate court upholds the conviction based on this particular flaw in the jury instructions. Now, there are other issues that will or potentially can be raised on appeal, and some of those might also provide some traction for Trump in trying to avoid this conviction. But this episode focuses on the state of mind issues, which are typically the key battleground in white-collar cases, as it was in this white-collar case. Now, I'm recording this episode in audio and video for a reason. The jury instructions, which were read to the jury in basically a 1-hour monologue from Judge Merchan, were very difficult for the average juror or even a lawyer to understand, and they had no visual aids to keep them on track. And keep in mind that the jury was not given a copy of the 55 pages of instructions. They were supposed to listen to these complex legal concepts, understand them, retain them, and then apply them. Not surprisingly, the jury came back the next day to ask for the jury instructions to be read again. Now, if you were following this trial closely, you might have heard why the jury did not have the written instructions. And that is because of a peculiar New York rule that it is reversible error to give the jury any kind of written text of a statute. And judges in New York are so wary of getting reversed on appeal that they simply do not provide the written jury instructions at all. And the jury cannot take those instructions back to the jury room for their deliberations to check over any kind of wording of the definitions or anything like that. Now, in my experience in the District of Columbia and in Massachusetts, juries almost always were provided a copy of the jury instructions. But the problem with these jury instructions goes much deeper. And it's based on the charges that the district attorney chose and the theories that they chose eventually to pursue at trial. The result was that the false record charges incorporated successive crimes and mens rea requirements within each other, like a Russian nesting doll. Or another analogy you could make is that each of the 34 charges were like boxes, with each box containing a series of smaller boxes. And each of these smaller and smaller boxes contained elements that the prosecution had to prove. Now, the mental gymnastics required to decipher each crime and how it related to the other crimes in the other boxes was to the point that it was impossible in my view, for any normal human being to understand exactly what the law was that they were being asked to apply. Judge Merchan's instructions, which he said he was trying to simplify and to make easy for the jury, did not do the job. The result is that the jury, in all likelihood, convicted Donald Trump without an adequate understanding of the law. Now, that's not the jury's fault. That's the fault of the district attorney's office in charging the case the way it did and pursuing the theories that it did. And it is Judge Merchan's fault for giving jury instructions that relieved the prosecution from proving all of the elements that it was required to prove. In this episode, I will explain the state of mind requirements of these crimes, unpacking each box within a box. And I will explain in particular where Judge Merchan's instruction on the federal campaign finance law fell short. And I will contrast it with the instructions in the John Edwards case. I think you will see how the different jury instructions given in the two cases explain, or at least help to explain, the different outcomes in the Trump and Edwards cases. Now, we're going to start with some of the visual aids that I promised before. And I want to start with first principles in explaining how these jury instructions came to be. So the crimes that were charged in the indictment came from statutes that were passed by the New York State Legislature. And to the extent that the state statutes picked up federal law violations, the crimes came from statutes passed by Congress. And so you have to unpack the words of the statute to understand them. Now, theoretically, you could just quote the words of the statute verbatim. You could just give the words of the indictment, because those words of the indictment, of the statute, necessarily contain all of the elements of the crime. However, that would be very unhelpful to the jury. The jury needs some explanation. Actually, the jury needs a lot of explanation to turn these very legalistic words of a statute into something comprehensible, something that they can understand and apply. Since you're engaged in that act of interpretation, you have to engage in what is known as statutory construction, which is a process that courts do all the time, including the Supreme Court, when they try to discern the meaning of a law passed by Congress. Now here, Judge Merchan was trying to determine the meaning of the false record statute passed by the New York State Legislature. And you do that by first looking at the words. What do these words mean? I say that because the judge is not deciding the law. The judge is interpreting the law. And in doing so, Judge Merchan and every judge engaged in this process of statutory construction goes by certain axioms or rules, such as that they have to give every word in the statute meaning, so that there are no superfluous words. And you will look at the purpose of the statute as you interpret it. These are some of the rules that you go by. However, that's not the end of it, because when you're interpreting a criminal statute, you're doing it within the framework of centuries of criminal law. And there's a basic proposition that crimes consist of two basic elements. One, a criminal act, which is known as actus reus, and a criminal mindset, mens rea. Remember, I used that word before. Now, if you're looking at the video version of this podcast, you'll see that I've put the actus reus, the criminal act, in blue, and the mens rea requirement in red. I will follow that convention as we go along. And you will see how the combination of the blue actus reus and the red mens rea produces the crime. Now, it could be that the crime has more than one actus reus, more than one criminal act that's required, and it's possible, as was the case here, that the crime has more than one mens rea, or criminal state of mind. But there is always some combination of criminal acts and criminal states of mind that make up any crime. So what was the statute here? You start with the New York Penal Law 175.05, the misdemeanor. Now, that was not what he was charged with, but that is the base offense that was augmented to the felony. So let's start with the misdemeanor. And what was the actus reus? What's the criminal act for the misdemeanor false record statute? Well, the language of the statute describes the act as, quote, makes or causes a false entry in the business records of an enterprise. So you can kind of shorthand that as the verb of falsifying or falsifies. In other words, Donald Trump was accused of falsifying, that he falsified certain business records of an enterprise, which in this case was the Trump Organization. And then the mens rea requirement was the intent to defraud. I'll be having a lot more to say about that intent to defraud later. So falsifying business records with the intent to defraud, that's the misdemeanor crime. Now, let's look at the felony. So again, let's look at the language of New York Penal Law 175.10, and I've quoted it here. It's when the misdemeanor includes, quote, an intent to commit another crime or to aid or conceal the commission thereof. So the felony has the intent to defraud mens rea plus the intent to commit another crime, the intent to aid another crime, or the intent to conceal another crime. Any one of those three would be sufficient. Commit, aid, or conceal. So for the felony, again, you have the criminal act, actus reus, falsifies, plus the intent to defraud, plus the intent to commit, aid, or conceal another crime. So let's keep going. So you have this intent to commit another crime. So what that means is that you have the intent to do the criminal act, actus reus, of the other crime, plus you have the intent or the mens rea of that other offense. So let me give an example. So let's say the other offense in this case was first-degree murder, falsifying business records with the intent to defraud and with the intent to commit first-degree murder. That's the example I'm using. So you would have the intent to kill, that's the actus reus of first-degree murder, and the mens rea of first-degree murder itself, meaning intentional, premeditated killing. Now, let's look at the actual other offense that was charged in the indictment and was the theory that the prosecution pursued at trial. So the other offense is this New York election law conspiracy. So what are the elements of that offense? Well, you have to agree with one or more people to promote the election of somebody for an office by unlawful means. So the agreement is the criminal act, and then the mens rea is the intent that someone promote the election by unlawful means. Now you might be stumbling a little bit at this moment, and I could imagine the Trump jury stumbling as well. Like, wait a minute, what's the act again? Agreeing? Is that an act? Well, in the case of conspiracy, it is. Even though agreement is really kind of a talking crime, much less than a doing crime, or it could be a writing crime or an emailing crime or a texting crime, you could enter into a criminal conspiracy by any means of communication. But it's that act of agreement that is the actus reus. And then the intent to promote the election by unlawful means, that's the mens rea. So what were the unlawful means alleged by the prosecution in this case? Well, the first was this federal election crime, FECA. And that was the same statute that John Edwards was charged with. So now let's look at the actual other offense that was charged in the indictment and was the theory that the prosecution pursued at trial. So the other offense is this New York election law conspiracy. So what are the elements of that offense? Well, you have to agree with one or more people to promote the election of somebody for an office by unlawful means. So the agreement is the criminal act, and then the mens rea is the intent that someone promote the election by unlawful means. Now, you might be stumbling a little bit at this moment, and I could imagine the Trump jury stumbling as well. Wait a minute, what's the act again? Agreeing? Is that an act? Well, in the case of conspiracy, it is. Even though agreement is really kind of a talking crime more than a doing crime, or a writing crime, or an emailing crime, or a texting crime, you could enter into a criminal conspiracy by any means of communication. But it's that act of agreement that is the actus reus. And then the intent to promote the election by unlawful means, that's the mens rea. So what were the unlawful means that were alleged by the prosecution in this case? Well, the first was this federal election crime, FECA. And that was the same statute that John Edwards was charged with when he paid hush money. So that's why the Edwards case is so instructive here. Their second option, the prosecution's second theory for this unlawful means, was falsifying other business records. And then their third theory was a federal or state false tax return. So let's review it again. You had to have had the intent to promote the election by unlawful means, and one of those unlawful means could be the federal election or campaign finance violation, or falsifying other business records, or a federal or state tax return violation. So let's stack up the mens reas so far. And I say stack because that's what's so difficult about this case. And this is what I think that the jury would have had so much trouble understanding. In fact, my bet is they probably didn't really understand it. So Donald Trump had to have had the intent to defraud. He had to have had the intent to conspire, because that other offense that they're picking up to make it a felony is conspiracy. So what does it mean to have the intent to conspire? It means the intent to agree. So Donald Trump had to have the intent to defraud, he had to have the intent to agree with one or more other people, and he had to have had the intent to promote the election by unlawful means. But we're not done yet. So the unlawful means, one of them, as I said, is this federal finance campaign violation. What are the components of it? Well, the actus reus, the criminal act, is to make a contribution more than $2,700 or a corporate contribution in any amount. And then there's the burden of proving the mens rea requirement of willfully. So let's review again this stacking of mens reas, the stacking of the criminal states of mind that Donald Trump had to have in order to be convicted. He had to have the intent to defraud. He had to intend to agree with one or more other people to engage in this conspiracy. He had to intend to promote the election. That was probably an easy one to prove. He was definitely trying to promote the election. And that he had the intent that a willful, illegal campaign contribution be made. Now, that is an extremely complex state of mind to prove and for a jury to grasp. I say that because I'm about to focus on a couple of definitions, intent to defraud and willfulness, two really key concepts that were essential to conviction. Now, my argument is that Judge Merchan got the instructions wrong on those points and effectively lowered the burden of proof. And the errors I'm about to point out come in the context of this four-layered state of mind requirement that is apt to confuse anybody but a criminal law specialist. And so any error in this already confusing state of affairs was going to be magnified in its effect. Now, here's the thing. The way the judge instructed the jury, the way that the prosecution pursued the case, the way it charged it, the way it tried the case, there were many paths to victory. So, for example, I told you, you could have had the intent to defraud, and then you have the intent to commit another offense, or you could have the intent to aid or to conceal. Any of these things were possible. So, for example, you could have had the intent to commit the tax violation, or the intent to conceal the campaign finance violation, or you could come to the conclusion that one of the other states of mind was possible and get to the conclusion that Trump was guilty. So I'm showing on the screen right now a flow chart that basically shows 9 different paths to victory with different criminal states of mind. And all of them have to be valid in order for the conviction to stand. Now, why is that? Because the way the jury verdict form was presented to the jury, the way the jury made its decision, it was basically an up or down thing. Either yes, he's guilty, or no, he's not. The jury didn't have to say which of these underlying unlawful means they were choosing. The false record, the FICA violation, the tax violation. They didn't have to be unanimous. And they didn't have to decide whether there was an intent to commit or to aid or to conceal. They just had this one basic decision, guilty or not guilty. So what that means is that on appeal, an appellate court has to be confident that all of these paths to victory were valid, each and every one. If any one of the legal theories underlying these paths to victory were faulty, or the jury instructions were not correct, or if the evidence does not support one or more of these 9 paths to victory, it's possible that the jury convicted because there was an error of law or because there was insufficient evidence. And because we don't know, and will never know, which path the jury took, any error would have to be deemed prejudicial and not harmless. And that would lead to reversal. Now, that's a high-risk prosecution strategy because, yes, there were 9 paths to victory, but there are also 9 ways to reversal on appeal. Now, I told you one of the intents, one of the state of mind requirements that the prosecution had to prove was intent to defraud. So what does defraud mean? Now, according to Judge Merchan, a person acts with the intent to defraud when his or her conscious objective or purpose is to do so. Well, that doesn't really say much, does it? It basically says that intent to defraud means that you're acting intentionally and not by accident. That doesn't really add much to the word defraud. It actually doesn't add anything to the word defraud. So Judge Merchan went on to say that the people, meaning the prosecution, need not prove that the defendant acted with the intent to defraud any particular person or entity. A general intent to defraud any person or entity suffices. All right, so that puts a little more definition on this idea. It's not limited to an intent to defraud a particular person or entity. Okay, that addresses the identity or the number of people or entities who can be defrauded. But what does defraud mean? And then the final thing he says in these jury instructions is that it's not constricted, meaning intent to defraud is not restricted to an intent to deprive another of property or money and can extend beyond economic concerns. Again, this is another statement about what intent to defraud is not limited to. So we find out it can extend beyond economic concerns. So if you are in this non-economic area, what is it that the defendant is depriving? What must the prosecution show? It's very unclear. Now, let's contrast the jury instruction about intent to defraud that Judge Merchan gave to the New York pattern instructions. Now, this is the first time I'm mentioning pattern instructions. What they do in New York and in other states and in federal districts around the country is that a committee gets together and they come up with some general instructions. Think of it like a cookbook with a bunch of different instructions on things like reasonable doubt, the right to remain silent, the elements of the crime of robbery, and so on. The judge can go into this big book of pattern instructions and take out the pages that the judge needs for each particular case. It allows the judge to avoid having to reinvent the wheel every time there's a new case. Now, the committee that puts together the pattern instructions has really studied these matters, and they're trying really hard and spending a lot of time to make sure that the pattern instructions are correct, based on the latest decisions of the court in that jurisdiction. And most judges are happy to just use the pattern instructions. Again, they're not trying to reinvent the wheel. But the reality, though, is that simply following the pattern instructions is not enough. So there are actually reversals out there where trial judges follow the pattern instructions, kind of following the cookbook, and then they still get reversed because the pattern instructions were wrong. There's no certification by any court that says that the pattern instructions are correct. Now, in this case, the pattern instruction for the false records felony simply says that the intent to defraud means that a person acts with intent to defraud when his or her conscious objective or purpose is to do so, just like Judge Merchan instructed. That instruction just says that you have to have the intent to defraud and you have to have the purpose of defrauding. That doesn't explain what defrauding means, but it does say that you have to act intentionally. Now, the New York pattern instruction I have up on the screen is for another fraud statute under New York law that also has the intent to defraud element. And the pattern instruction for that crime does give a little bit more detail. So one of these instructions for this other fraud statute, it says that a person acts with intent to defraud more than one person or to obtain property from more than one person by false or fraudulent pretenses, representations, or promises, when that person's conscious objective or purpose is to do so. Now, this instruction, while it's a little sparse, it does add some important explanation that Judge Merchan left out. And what he left out was this idea of false or fraudulent pretenses as a means of obtaining property. That gives some definition to that term defraud. Now, let's talk about the federal definition. And I'm putting up here the Federal First Circuit instruction. I think it gives what I think is an even better explanation of what defraud means. The First Circuit pattern instruction says that the term defraud means to deceive another in order to obtain money or property by misrepresenting or concealing a material fact. It also includes a scheme to deprive another of the intangible right of honest services. So that last part about honest services, that has to do with something called honest services fraud. So in other words, there could be a scheme to defraud, and this usually comes up in corruption cases, where the wrongdoer is not attempting to get money or property, but is trying to get a public official or somebody who has a duty to a government agency or a company to kind of feather their own nest or feather the nest of someone else, even if they're not taking money. What's being deprived is the honest services of that person, of the person doing their job in the right way. So when Judge Merchan said intent to defraud could extend beyond economic concerns, that's probably what he was gesturing at, even if he didn't really explain it. But returning to this term defraud, it's this idea of deception, that you're saying something false in order to cause a behavior. In other words, you're trying to get the person who's receiving the false information or the false promise to act in reliance on the false statement. And it's that concept of deception that gives the term defraud its legal meaning. Now, let's look at Black's Law Dictionary. So this is a more general legal definition applicable across all states, which says that an intent to defraud means an intention to deceive another person and to induce such other person in reliance upon such deception to transfer a right with reference to property. Now that really explains it quite well. It's the idea of deceiving, in other words, giving false statements, false representations, false promises, in order to induce somebody to do something. In other words, to give you money, usually. What's missing in Judge Merchan's instruction is this intent to deceive and the idea of a reliance, that somebody hears the false statement, or in this case, sees the false business record and does something. So why is this so important in this case? In this case, you can legitimately ask the question, well, who was Trump defrauding? These false records were his own records. This is not like somebody submitting a false bank loan application where you're trying to deceive the bank to give you money. These false records were his own records, the records of the Trump organization. So to the extent they were false, who is he deceiving? And what is he trying to obtain? That's kind of a live question here. This is not a case where Trump was lying and getting people to send in money based on those false representations. But what the prosecution was trying to advance in the Trump case was kind of a different kind of defrauding. After all, Trump was the one who was paying out the $130,000. So the question is, who is he trying to deceive? And what was he trying to obtain? It's more than a little counterintuitive. So getting a clear definition of defraud and intent to defraud was critical here. And the problem here is that the jury, under this instruction, and based on the evidence that it heard at trial, could have convicted Trump on this intent to defraud element simply because they saw that there were some false records or false statements. And that's just wrong. Defrauding means more than making false statements. There has to be an element of deception and inducing behavior. And it also means obtaining something or of depriving someone of something. And that was never spelled out to the jury. In this jury instruction on intent to defraud, the jury was told what it did not have to find. In other words, what defrauding was not limited to. But I don't think Judge Merchan ever got down to saying what the prosecution had to prove. What was the bare minimum the jury had to decide under Judge Merchan's instructions? That explanation was never provided to the jury on this critical concept of intent to defraud. And that's why I think this intent to defraud instruction has a very good chance of being the basis for reversing this conviction. Now, let's go to the more glaring issue, the even more glaring issue, which is the instruction, or should I say the lack of instruction on willfulness. And this is the one that I would be losing sleep over if I was the prosecutor. So this is what Judge Merchan had to say about willfully, and it came up in two contexts. One, the campaign finance violation, the federal one, and then the tax returns. Okay, so this is the sum total of what he's saying about willfully. He said, it is unlawful for an individual to willfully make certain campaign contributions. And then with respect to the tax return, he says, it is unlawful for a person to willfully make any false tax return. Okay, that's it. Based on that, do any of you know what willfully means in a legal sense? Just based on that. Because Judge Marchand did not explain willfully at all. I mean, at all. He just used the word willfully in those two sentences, and that was it. All right. So let's start with the dictionary meaning, the ordinary dictionary meaning, because that's probably what the jury is going to understand willfully to mean in the absence of any explanation of willfully in a legal sense. Okay? So willfully, with the dictionary, these are three different dictionary meanings. One means with the intent of causing harm deliberately. So in other words, willfully means deliberately. So that's another way of saying intentionally. Another dictionary meaning is that willfully means with a stubborn and determined intention to do as one wants regardless of the consequences. So willfully means that you're being stubborn and determined. And then a third dictionary meaning, ordinary dictionary meaning, is that you're acting obstinately or intentionally. So under these dictionary meanings, willfully really doesn't mean anything different from intentionally. Well, the legal meaning is very different. Intentionally and willfully are very distinct mens reas. Okay, this is the legal explanation of willfully in a federal pattern jury instruction. An act or failure to act is willful if done voluntarily and intentionally. And here's the key point. And with the specific intent to do something the law forbids. With the specific intent to do something the law forbids. Or with the specific intent to fail to do something that the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. Thus, if the defendant acted in good faith, he or she cannot be guilty of a crime. Now, if you listen to the podcast that I gave 2 episodes ago, where I got into willfulness, I explained this, and basically it's a knowledge of law requirement. In other words, you are not acting willfully unless you know what the law requires, and you're deciding to act contrary to the law, or you know what the law requires you to do, and you fail to do it. Willfully is a very hard thing to prove if you're a prosecutor. Every case that I've ever done where there was a willfulness requirement, that is just something I was focused on all the time because it's really hard to prove, and you have to bring up evidence showing that the defendant had some familiarity with the laws that he is alleged to have broken. So let's look at how the Edwards trial judge explained willfully in a very similar hush money case with the same FICA violation. This is what the trial judge in the Edwards case said. The government has to prove beyond a reasonable doubt that Mr. Edwards acted knowingly and willfully. The word knowingly means acting voluntarily and intentionally, not by mistake or accident or other innocent purpose. The word willfully goes beyond that. So if you're looking at the video version of this podcast, I put this part in red. Willfully goes beyond that. Willfully is more than intentionally. It's more than knowingly. And it requires proof that Mr. Edwards acted with knowledge that his course of conduct was unlawful and with the intent to do something the law forbids. And again, not by mistake or accident. In other words, a person acts willfully when he acts with bad purpose to disobey or disregard the law rather than in good faith. Now, look at how different that was from what Judge Merchan did, in which he just put the word willfully out there and provided no explanation. Willfully is a very distinct legal concept, and it's at variance with the ordinary meaning of it. Ordinarily, you think of willfulness as just really intentional or obstinate, or you're really set on doing something. That's not willfulness in a legal sense. And that legal sense of willfulness was missing in the Trump jury instruction. Notice the much greater level of detail in the Edwards jury instruction on willfulness. In fact, the whole instruction on the federal campaign finance law violation was 5 pages in the Edwards case. And Judge Merchan's instruction on the same violation was 1.5 pages. And so things like an explanation of willfulness, that key criminal state of mind requirement, were left out of Judge Merchan's instruction. Now, that matters because the jury may have convicted Trump because he acted intentionally and deliberately in paying the $130,000. That's not enough. He had to act willfully in a legal sense, in that he knew he was violating a campaign finance law. And as I explained before, that federal campaign finance law might have been the path that the jury took to get to the guilty verdict. And because of that, the error in failing to instruct on the willfulness standard is prejudicial, and I don't see how the verdict stands. Now, you may ask yourself, how could such a high-profile case be derailed by a part of a jury instruction that almost nobody is paying attention to? First of all, you can see how cable news programs with their short attention spans and reporters not used to trying these cases could be drawn instead to the colorful personalities of Stormy Daniels and Michael Cohen instead of these jury instructions. But how could Judge Merchan make such a misstep? Now, one news report I saw said that Judge Merchan does not like to deviate from the pattern instructions. Some judges do just follow the pattern instructions no matter what. So on intent to defraud, he followed the sparse explanation contained in the false records pattern instruction and called it a day, without including some real explanation of what defrauding means in a legal sense. And on willfulness, for the federal campaign finance law violation, there was no New York pattern instruction at all, because the New York pattern instructions just include New York state crimes, not federal ones. So the cookbook he was used to using didn't have the explanation for willfulness. But how could the prosecution allow this fatal flaw into the jury instructions? The prosecution has not succeeded until the jury verdict is affirmed on appeal. So yes, they were trying to convince the jury, but the prosecution also needed to avoid reversible error. And as I said, they were taking a high-risk strategy that opens them up to getting reversed on appeal. But this complete lack of explanation on willfulness is really hard to understand. More amazingly, the prosecution wanted Judge Merchan to leave out the word willfully completely. So let's review. First of all, the jury instructions were problematic because they were so confusing. Because you had these different mens reas that were stacked upon one another in a pretty confusing way. Now, will that alone lead to reversal? Probably not. The reality is we never get to determine whether the jury actually understood something. We do not poll the jurors afterwards. That's not part of the process, but it was pretty confusing. Then you have the defraud problem, not explaining the term defraud in a case that was not a classic defrauding situation. This was not a case where Donald Trump was lying to people in order to get them to send him in money. Now, I'm sure some of Donald Trump's critics would say that Donald Trump has done just that on other occasions, but that's not what this case was about. This was about Donald Trump sending the money out in order to buy silence. He was not trying to obtain money from people. So you've got the defraud problem. And finally, the number one issue, which I think is really the fatal flaw, the complete lack of explanation on willfulness. And this is where I fault the prosecution. The prosecution was trying to take willfulness out of the jury instructions entirely. I don't know what they were thinking. If they wanted to make one of the predicates, one of the unlawful means, one of their options, the federal campaign finance law, well, willfulness is part of that. You can't avoid that. If you don't want to prove willfulness, don't make that one of your predicates. So I think that Judge Merchan, what he did was kind of split the baby. He said, okay, fine, defense. I'll give you willfully. I'll put it in there. But then he threw a bone to the prosecution and then didn't explain it. And unfortunately, splitting the baby does not necessarily mean you were right. And I think that's going to be the undoing of this case, because the legal meaning of willfulness is so different from its ordinary meaning. So that's it for today. I'm Alex Grant, and this is the Law of the Case podcast. You can find us on Facebook, Twitter. You can find us on most podcast apps, including Amazon, YouTube, Spotify. And you can email the show at lawofthecase@gmail.com. Until next time, I'm Alex Grant.